Chairman Wontumi ni new lawyer a friend lawyer Atachiano a osan so ye counsel for Kwabena Edubuahin. Sa lawyer we Wontumi mfa Chairman Wontumi entwa Jericho afesuo because ekwan a ofa so take over Chairman Wontumi case from lawyer Andy Apiakobi abusua sa kwan no sa fake criminalities anase taxes bi a omode ba bewura Chairman Wontumi game no abusua court no judges no omo collapse sa deal no na ene asem foforo asanso ato lawyer Atachia Èxp0sè the main reason why a lawyer Atachia obefa Chairman Wontumi case no akesefo de sa ensem no aba betudwa abusua yensem mbrɛ mom yenko na yenkonkotie ensem a lawyer Atachia ensem a ato no political highway no so na yeba yede diaka ato am so na Ghana has a open computer papa and a laptop papa na where use abura periodic computers and accessories ho na obenya laptop papa e dey free location enya your akwan o Kumasi Wokrom Estate a life number ya egu ye screen ni enchen 0247030108 and I say 0597942133 periodic computers and accessories ho na obenya laptop papa na computer papa na where use mom yanko na yenkonkuti ensema lawyer Atachia as counsel and as a new lawyer for Chairman Wontumi and some Èxp0sè our political highway so ye ba ye di aka ato amoso
Wontumi surely. And July seemed to be a special month for him. There are two very important dates in July that will matter to him, the 3rd of July and the 6th of July. What's even more interesting is you recall that his lead counsel had indicated that he'd like to withdraw. He cited a few reasons why he'd like to withdraw from being counsel to Chairman Wontumi. We also saw that lawyer Atachia says that he's taking over the criminal side of his case. What does that mean? Let me ask the lawyers first before we even get to the other matters. So, if you follow the conversation, Atachia's announcements yesterday, or maybe a day before yesterday, what does that mean to the ongoing case?
So, let me wish your lovely viewers a good morning. Wish yourself a good morning. Always a pleasure to share a platform with my brother Wontumi. Today, my uncle himself has come to accost me, so I must be on guard. A good morning, uncle, and my brother, my learned brother, a good morning. Well, I think the announcement by Atachia means what it means. Simply change of solicitor. As in, we should not read too much into it because. Like all contracts, I think Wontumi has the right to change his counsel, or the counsel himself also has the right to remove himself from the case. So I don't think we should read too much into it, except to say that from what I'm saying, maybe it may be strategic. I don't know, but I'm thinking that maybe it may be strategic. And the strategy or the purpose of that strategy, in my opinion, being to try as much as possible to prevent the judgment, the supposed judgment on the 3rd of July from being read. Because, I think they give them a date to more or less file their written submissions. Now, that is very critical. Because it is in that submission where you make your arguments, you try to persuade the court. You must understand that in criminal cases, generally, the burden always is on the accused to prove, to persuade the judge as to the guilt of the accused. Now, that does not also take some burden from the accused here, especially since the submission of no case didn't work. So personally, for me, I'm not reading too much into it, except to say that I think that I see a strategy here, and the strategy is to try as much as possible to push the judgments.
The 3rd of July that the court is.
Yeah, because Atachia would need time, really, because he was not a lawyer on the case. Because he is going to.
I see he's starting that argument that it would be unfair. So he's hoping that the
these arguments we all make. I think because what you will say, we all make those kind of arguments when you enter the case. But I'm saying that's a strategy here because really. for me, the reason was called my learned friend, and the appeal could give for leaving the case for me is not tenable, except that he has a right to remove himself from the case. The strategy for me is to find a legitimate excuse why the judgment on the July 3rd cannot be read, and because there's a new counsel in, and yesterday you heard him say you need time to go through the docket to prepare what's called, or to file his written submission. That's normal. We all do that, and we should give them that.
Even when the courts rejected the idea for the lead counsel to abandon the
court didn't reject it. You should read argument. So what the court said was that Apiaku didn't need that process as a reason to leave the case, as in he could leave the case. So it wasn't that the court rejected. Really, you don't need the court's permission to enter into a contract or not to enter into a contract. So if you read what the court said, the court simply said that Apiaku did not need that application. You understand? That application was incompetent, in fact, to use the words of the court, and that he had the right to, by simply filing, by what's called the accused simply filing, what's called
change of solicitor.
Change of solicitor to change him. So it wasn't the court didn't refuse Apiaku.
It was a confusion many didn't understand, because it's sounded to many Ghanaians that, well, but if the court didn't accept, which I'm glad that you point the confusion in there. You can't force a counsel to be...
Exactly.
Yeah, so it was just a process.
It was a process. So the court simply was saying that you don't need this process to take yourself out. Yes, and I think they have done that. So right now, Attachia is counsel. And I cannot argue against that, because like I said, it's something that we all do to be honest. And it will be unfair not on even the counsel, but on Wontumi. Because you see, per the principles of natural justice, all opportunities has to be afforded him to defend himself. And so I think that it says right for Attachia to seek a bit of time to go through all the processes and then file the first right and then file the case. I think they should be, the court can accord him that. But for me, I'm saying that...
Should the court accord him that?
I'll be a hypocrite if I say the court should according to what, like I said, I use that, it's not that we all do. I sit on TV and say that.
The lawyer laughing.
Yeah, it's something that, okay. It's something that, so I'll be very...
It's a trick, eh?
It's not a trick. I'll be very hypocritical.
It's a module you use, one of the ways.
No, it's not one of the ways. But you see, when you enter a case fresh, you'll be very irresponsible.
But you don't just enter. You enter and you're giving everything, how it started, where you are and where you are.
But in that huge docket, you think that you need time to go through, especially when the written submission, hasn't been filed. If the written submission had been filed, then probably we could make it. But while the written submission hasn't been filed, the new counsel would need time to go through, the
criminal cases he represent changing lawyer for.
The summary boy.
The summary boy, not the one that they are seeking.
Not Èxp0sè.
Not
the plea bargain, is the summary boy. Illegal mining.
The date for judgment have already
because what happens is that they'll give you, we are giving you, let's say, 6 weeks or 2 weeks or 3 weeks to file your written submission. So file your written submission by...
Which should be due 24th for that particular case, 24th of this month.
And then 3rd July for judgment. So what they did was they changed the counsel before the written submission was even filed. I'm saying that it would be unfair on the part of... it would be unfair on Wontumi himself if the new counsel is not given enough time to go through, because he wasn't in the case, to go through the processes. That's what I'm saying as his strategy here. But I'll be a hypocrite.
Your head. If you were in Wontumi,
I'll be a hypocrite if I sit on TV.
A child is sick and he would die.
It's illegal.
Like put him in the packet of the poop.
Oh, nobody's...
That one I agree with you.
Until we put him in that bucket.
Let us put him.
I think the whole Ghana knows, but the point I'm saying, it would be very highly hypocritical to sit on TV and say that Attachia should not be given that opportunity. Because for all intents and purposes, he wasn't in the matter. And to be very unfair on to himself. So they should grant them that opportunity.
Okay.
But like everyone is saying, I'm sure the judge by now understands the case very well, and he's going to dispense with justice.
Okay.
You should trust that the judge is going to dispense with justice.
Well, Honorable, I see where you're taking your argument from already. You started from the Pope's pocket.
Well, I think that, again, like my brother said, it will be unfair. First of all, let me say good morning to the people of Trifuetimokwa. I mean, I am representing in Parliament. It would be very unfair for anybody to say that Wontumi have no right to change solicitors if that's what he feels he want to do, or if the solicitor himself representing him, my own brother Apia Kubi, feel that where I've reached, I think that I've exhausted my capacity to deal with the issues, or there are many reasons why as a judge, a lawyer would want to recuse himself from continuing representing a client. One could be that, okay, the fees that I charge the client to pay me, he's not paying, therefore I don't think my services will be available to my client again. That's fine. It could also be that they do not agree on principles of strategies as to going into the case here and there. So let me recuse myself because what I'm trying to do, my client is not interested and is not understanding. So that could also be a reason for a counsel to recuse himself. So there are so many reasons.
Apia Kubi is very clear.
Again, there's another reason that Apia Kubi is citing is that there are certain things that the court is doing that he is not able to take.
Yeah.
I wonder how Atasha is going to take what the court is doing anyway, that Apia Kubi couldn't take. But that's for them to do. Nobody can seize or challenge and deny any individual as the kind of person to represent them, especially when it comes to dealing with matters of criminalities and all that. But you see, when you go into the mind of the situation, you begin to reason through certain things. I mean, all the accused, witnesses have been called and they've been interrogated. The case have closed. They are supposed to file a written submission. Then judgment will be delivered. Now, Apia Kubi realizes that he couldn't continue again. Is it that he's not able to write the written submissions? He's incompetent, incapacitated in writing the written submissions?
No, why are you going outside of the reasons he has submitted?
Well, the reasons he has submitted, again, I have my right to also reason through the reasons because he submitted. Mm-hmm. He cannot also, if you like, chain me to the reasons that he submitted. Again, so the question is that what is it that may necessitate? When the case started, when they were doing the case right from day one till the case closes, he didn't see reason to recuse himself. Now it is time to write written submissions and the judgment is delivered. Now he sees it. So the point is that somebody may reason, if you like, with me, that it's an attempt to delay the case and trying to see whether, the Exim Bank, for example, issue, now pre-bargain and all that. So it's trying to massage things and all that. But like I said, what will happen will happen.
Okay.
Judgment will be given. But I trust the integrity of the court. And I believe that the court will give judgment according to the merit of the case.
That's fine.
Will not be on anybody's... Today, I see some social media running around. People are trying to do some social begging of people and all that. That is not...
I'm sorry, about what?
Yeah, about people thinking... I saw some video where Wontumi on radio, I'm not bigger than begging the former president for insulting him, the current president for insulting him and all that. But and I feel so bad because His Excellency John Dramani Mahama, I tell you what, he's not even interested in the case. He's not following the case. So people thinking that when we go begging President Mahama, we weigh the merit or where the case should go, the judgment and all that, that totally should be taken out of the equation because His Excellency Mahama is not even thinking about what is in court. He's not even interested. This is purely about Wontumi and his own issues and the court of competence coordinates and so forth and so on. So everybody, individuals will feel that going to His Excellency Mahama will have anything to do with criminality, determination of criminality in our courts, and a court of competent coordinates should begin to reason differently. So that, Tokonu told us the law is the law. So, so let's allow the law to continue to be the law. Going around this little gimmick here and there.
Every other thing Atacha is asking for is also in law. Anyway.
I mean, there's nothing really that is going to change. What is going to happen will happen.
Okay.
The judgment will be delivered. If it is today, it will. Tomorrow, it will. Tomorrow. I mean, whatever it is will happen.
Okay.
And so for me, I think that let's continue to pray.
For who?
And
pray for who?
Let's continue to pray for Ghana. Let's continue to pray that justice will continue to be delivered according to the merit of the case, but not whom you know and who knows you.
Okay. I think it's a good place to land on that prayer note. Let me go to Uncle.
I hope you are not being sarcastic.
You'd rather go to the lawyer.
You say you are dealing with the lawyers. Me, I'm not what do you refer to yourselves?
Learned.
I'm not a learned person, but
I started with the lawyer.
What kind of book they read before they call themselves learned?
I'm a learned person.
Yes. I started with the lawyer because I wanted him to situate the matter that has come from there. You see to him, right? Yes. Okay, well, Kwesi.
I'm a father.
Is this a module? Is this a tool you would use as a lawyer to buy time?
I, from my little years or my few years in legal practice, I've come to realize that legal practice is not just about the law. It's about strategy as well. Mm-hmm. A good lawyer, I think, is a lawyer who knows the time to use the law and the time to employ strategy.
Did you hear that?
You don't always need the law. Sometimes you need strategy. And strategy actually plays out even during your cross examination, like counsel mentioned, even how you write your written submission. Because there is no formal template on how you do these things. And so you need strategy. And so strategy is part of law. But let me start by saying that the right to legal representation is a constitutional right. Every accused person has the legal right to legal representation. And that I do not think that the courts in Ghana can compel any accused person to be represented by a certain lawyer or a particular lawyer. The choice of legal counsel is at the discretion of the accused person. It's at the will and desire of the accused person. It is the accused person who has the right to appoint any solicitor he or she feels he can work with. And so I think that Wontumi, to start with, has that right. Secondly, as we speak now, Wontumi is still innocent because the Constitution prescribes that every accused person is presumed innocent until proven guilty by a court of competent jurisdiction. To the best of my knowledge, Wontumi has not been convicted or has not been proven guilty by any court yet. And so the matter has not been concluded yet, even though trial has ended, because trial starts from somewhere and it ends somewhere. You start with CMC, the prosecution will now do its case, and there will be the accused person has the right to file an application for submission of no case. If the court deems that the accused person has questions to answer, the court will order the accused person to open his defense. The accused person will also now put out his defense, and then at the end of the day, the trial will come to an end, and then counsels will write their written submission, which is not mandatory anyway, and then the court will give its final judgment. And so, as we speak, like counsel rightly mentioned, the burden still rests on the prosecution. The Constitution requires that, or our criminal justice system requires that the Constitution prove its case beyond reasonable doubt. What the accused has to do is to raise a shadow of doubt in the case of the prosecution, and the accused person is good to go. Now, we are being informed that the lawyer for Chairman Wontumi, and let me add this, that just as the accused person has the right to appoint his lawyer, a lawyer of his choice, the lawyer also has the right to also accept a client of his choice. The lawyer can decide not to accept you. For instance, if Honorable Wondi brings me a civil matter, I can decide to accept. Because the civil matter, the legal fees will be good. But if he brings me a criminal matter, I can decide not to accept. So it is a two-way, you know.
Are you suggesting that Wontumi was not paying his lawyer?
Oh, you know, actually, I've not said that, but that is also one of the grounds under the Legal Professions Act for a lawyer to decide not to represent a client. But that is not the reason Addo Akubi, the learned Addo Akubi, has given. And so let's respect his reason.
Well, I'm only suggesting that to you anyway.
And so the lawyer can decide to choose his client. Now, in the spirit of fair trial, if the client feels that at a point in time he cannot work with the lawyer, or the lawyer feels that at a point in time, for certain stated reasons, he wants to change his lawyer, in the spirit of fair trial, it is only appropriate that you allow the accused person to go with the lawyer of his choice. And in the circumstance, we are all aware that a date for judgment has been set. Now, the question as to whether or not Counsel Atachia would plead with the court for an extension of time to enable him study the record of proceedings of the court, to enable him put together a very solid written submission. Let me also state that extension of right is not as of right. It's at the discretion of the court. The court can decide to reject that. I don't know if you come by way of motion or by way of oral application. The court can decide not to agree with Counsel Atachia and refuse his request for extension of time. And the court can still be firm on the date set for judgment. Like I've already indicated, legally, written submissions are not mandatory. Some lawyers even decide not to write written submissions. It's not mandatory, you understand? And so I think that let's allow the judicial process to work. Counsel Atachia is a consummate lawyer. He's been at the bar for over 33 years. I wasn't born when he was called to the bar. He knows the law far better than I do. He knows what to do. He owns one of the biggest law firms in this country, Zoe Achia & Co. His wife is also a consummate lawyer. His first son is a consummate lawyer. And so it's a family of legal brains. He knows what to do. I will not sit here and advise him on what to do. I will not even try to do that. I will not sit here to advise counsel and the Addo Akubi on what to do. I will not even try to do that. But all that is happening is permissible within the legal and criminal justice framework. And so let's not read political and mischievous reasons into what is happening.
While you draw attention to the fact that the court can decide to want to, change the date or maintain the date, they already said, how common is it for a court to actually change the date they set for judgment?
It happens all the time.
Is it quite common?
It happens all the time. It happens all the time. Even in civil matters, it happens all the time. Like Counsel mentioned, change of solicitor or...
Not the solicitor.
No, I'm saying it goes hand in hand.
Okay.
So once you appoint a new solicitor, he will need time to study the record of proceedings because before he can make any meaningful argument. Because lawyers have a lot on their plate. You don't call a lawyer today and the next day he's in court arguing as if he's been with you since day one. No.
Right.
And so it is only proper and in the spirit of fair trial that you allow the accused person's counsel, new counsel, the opportunity to study the record of proceedings. And I am even aware that the learned Addo Akubi actually appealed the decision on the submission of no case. And so all these things will come to bear. Counsel can even make the point that because there is an appeal pending before the Court of Appeal, which is higher than the High Court should arrest its judgment. Because if the High Court proceeds to give its judgment on the substantive matter and the application for and the appeal for the submission of no case succeeds, that will amount to a mockery of justice. You understand? And so there are so many things that Counsel Atachia can do. Like I'm saying, he's a consummate lawyer. He's been in this game for a very, very long time. He knows what to do. And I am only praying that in the spirit of fair trial, the courts also know what to do because the matter is still before the court. I would not want to go into the details of the court and whatever. But to land on what Honorable mentioned, that he is in a video of Chairman Wontumi pleading with President Mahama. I think that in all sincerity, today it is Chairman Wontumi, tomorrow it may be Honorable Wondi because he's a board member of SIC. So tomorrow it may be him. So in all sincerity, and he's a public officer as a board member as well, he receives taxpayers' money and all that. He receives fuel allowance and all those things from the board. So tomorrow it may be him. So I am speaking from the standpoint of Chairman Wontumi being a Ghanaian standing trial. In all sincerity, we are being told that he's being prosecuted under the ambit of oral. But the charges before the court has nothing to do with embezzlement of state funds. And so I have been wondering how Chairman Wontumi's Samra Boy matter of his alleged assignment to a third party without going through the right legal process. I am wondering how that amounts to Operation Recover or Loot. What exactly is the state seeking to recover in this matter? What monies has Chairman Wontumi stolen from the state?
Are you in any way suggesting that because commentaries suggest that Operation Recover or Loot, the Attorney General has all the powers to want to initiate different...
Under the policy framework for Operation Recover or Loot, we were told that people have embezzled close to $21 billion.
Yes. At the time was Chairman Wontumi's matter cited in that 21 billion.
No, that vehicle was to recover the 21 billion. They didn't tell us that Operation Recover or Loot was to go after people who have been alleged.
When the Attorney General
I am not saying Wontumi cannot be prosecuted. That's not what I'm saying. But I'm saying that regarding what Honorable mentioned, there is a perception, and all of us around this table will agree that there is a perception that what is happening to Wontumi is political witch hunt.
That's not true.
There's a perception, and we cannot discount and invalidate that perception. And so if the person himself has found reason and cause to sit on national radio to appeal to the president, then that fits into the larger perception that because some people believe that Chairman Wontumi in the heat of the campaign said something against the then opposition leader, and that now he has political power, and so he wants to teach him a lesson. I think that all these, that's why I said perception. All these perceptions are things that, you know, at the end of the day, I mean, but
would you not be quite disingenuous towards the court to know that the court will sit on matters that have substance? If it's political witch hunt, the court will sit on anything else.
But a political matter.
If it is witch hunt, if it is witch hunt, and then the Attorney General can present cases that can be found are criminal.
A witch hunt can be a case that has substance. When the matter is described as a political witch hunt, it doesn't necessarily mean the matter is without substance. No.
But you agree that we've used this witch hunt over the period, suggesting it there.
And I'm saying that
there's no case.
And I'm saying that
you can't take witchcraft matter to court by the way.
You said why is he
the accused person has, you know, he's had cause to believe that maybe the certain president, in some way or the other, is offended by certain things he said about him. And that is why. And I'm saying
that if indeed the president feels disrespected, I mean, he has courts to go towards defamatory. But if the Attorney General goes into that matter, that fact, and gets fact, and get issues that are quite criminal, he can just pursue it.
That's why I said that there is the perception.
That perception.
I have not seen the video. I have not seen the video of the respected Chairman Wontumi on radio, quote and unquote, begging President Mahama. I have not seen the video. But from what Honorable is saying, that he has seen the video. And I'm saying that if indeed the regional chairman has done something like that, then it fits into the larger perception.
But he is attempting to want to actually debunk that perception that if you think that the president is the one that is interested in you, and I'm saying that, but he is here saying that, I didn't want to go there, but since you've introduced it, my understanding of his submission is that if you think that because you had made certain comments about then candidate Mahama, which is why you are being witch hunted, I am giving assurances that the president is not even interested in this matter
at all.
The Attorney General is the one looking at facts and wanting to see. How will
in all sincerity, Honorable Wondi cannot say as a matter of fact that the president is not interested in this.
He's interested in anything that's illegal mining. He's been very public about that. Yeah.
Honorable Wondi cannot say as a fact that the president is not interested or is not aware about the prosecution of.
Aware is different.
I'm sure you
Aware is
understand the
different
English
from
language,
interested.
interested and aware.
Yes.
Whether or not the president is even interested, that's not even my concern. The point I'm making is that there is a perception. And the person who is standing trial now feels so alarmed to the extent that he has to sit on national television to beg the president. Then that feeds into the larger perception. And so, LFA, I would not say more because this is still a matter pending before the court.
Okay.
I will only pray for fair trial because counsel Andiapia could be resigned as counsel for Chairman Wontumi on grounds that the judge has not been fair to him. And so,
do we not hear this all the time?
I will plead.
If it is not going your way.
As a lawyer, have you not heard this all the time?
Okay, abusua we ne ensma ekoso e political highway ne so lawyer atachia e na chesem painful e de ne ho nsem etudwa ene ekwan a ofa so e be fa Chairman Wontumi ne case ne strategy a opese odira case no eno e na ye de brema be da masesa mo je pene kokoti za ensem we e de mai aha e gossip politics TV so